what the public and what others see about the amount of work one puts in this profession, in this vocation. There's a lot of work, and I've learned to accept, or I have accepted for a while to go, that there's no escaping doing the hard work yourself, and that there's no escaping reading the documents yourself, and going through everything yourself.
On to a thorny issue, and I was reminded of this when I went through the comments from the professional bodies, especially that of the GCP. Your interview in April 2018, I had recently become a member of the JSC then, and I vividly remember those interviews. And I remember being left with a very unsettling feeling after your interview when you were questioned by the then JP, Judge Dennis Davis. That was quite an unpleasant exchange, to put it mildly. And that just made me wonder about your temperament. As I experienced it, you lost your temper, and it just unsettled me that a candidate for a judicial position would actually allow themselves to lose their temper in front of the JSC. Do you want to comment on these observations of mine?
Yes. Look, I'm sorry. It's clear to me anxiety got the better of me on that day. I'm sorry about that. It has never been a problem between me and Judge Davis. I mean, we've worked together very well. But on that particular day, I did get riled, and I think I regret it. I mean, I did say to him that your eye contact with me is beginning to disrupt my trend of thought. And yes, I didn't intend to insult or hurt him, and he never saw it as that. And as I understand it, the JSC never thought that it was something that I acted out of order. But if I did, I do apologize for it. And I certainly regret that. But it's certainly not an indication of me losing temper all the time. I mean, that's just, that would be an inappropriate conclusion.
But then there are the comments made by the JSC. I'm just going to confine myself to those relating to your temperament, and they report on what they say counsel has told them, that you have been described as abrupt and discourteous at times with counsel, that is. That to me tends to show a pattern, a quality that you have.
I don't think that's correct, Deputy Chief Justice, and I'd have to say why. Firstly, I know some people dissociate themselves, because the way that comment is written, it says thereafter that other senior counsel do not agree with it and dissociate themselves from that comment. But that's not what I would rely upon. I do accept that I can sometimes be firm with people, and I have said this before in front of to this body, that I have sometimes been forced to be firm in court in order to make sure that there's order in my court, in order to ensure that there's decorum in my court. And if you don't do some of those things, then you can lose control of the process. So I have sometimes been that. And yes, I'm a human being with some flaws. I'm not going to sit here and say I'm a perfect human being. That would be,
none of us are perfect, Judge Bali.
Sorry, Madam.
No, I was just saying none of us are perfect.
Thank you, Chief Justice, yes. So I don't think that that's entirely correct. I mean, I have never received specific complaints from any one of them. And sometimes people don't like the decisions you take it, and you have to tell them about it, and they sometimes see it as being harsh and discourteous. I don't know, I can't speak for them, but I'm just speaking generally. So no, I don't think that's a fair comment of my general approach in my court. I really don't think so. In fact, the
Well-
contrary.
Sorry, have you finished?
Yes, I am finished.
All right. I raise these difficult questions, and I'm sure you can tell that I'm quite uncomfortable putting them. I raise them because the Supreme Court of Appeal, being an appellate court, requires a team player.
Yes.
You would not be sitting alone there. Well, you are in the appeal court as it is now, so you know what I'm talking about.
Yes,
Most of the time you work with 4 other people
yes,
and it's, wherever you get more than one person, there are going to be personality clashes and all of that. So it is important, and the SCA coming with its history, coming from where it has been, collegiality matters quite a lot there, and it's a delicate exercise. So, and I mean, quite apart from that, you mentioned the decorum of the court, so judges need to behave in a specific way. There's the judicial code of conduct that requires us to be a certain way, especially towards the counsel, the people who ply their trade in our courts, the litigants. So a judge cannot be rude, a judge cannot be impatient,
Yes.
a judge, you understand what I'm
Yes.
trying to say to you. So it is, issue of temperament is quite critical. And that's why I need an assurance from you that you can be a nice person, if I can put it simply.
No, I can give you that assurance, unqualifiedly. I've sat in a number of 3-bench judgments. I've sat in the competition appeal court, quite a lot, in fact, in the competition appeal court. So yes, I've been sitting with other judges. I've accepted the lead of other judges when they're leading it. I've led benches. I've led the 3 benches. I now lead almost in every competition appeal matter that I sit, I'm the lead judge now, because I'm the most senior judge in that court. So yeah, I've done that. I've had the control process, and in none of them can it ever be said that I've not acted collegially. What can be said is I have dissented in my judgments, but that's not uncollegial. I have issued dissenting judgments. In fact, they're on record there. But it's never been uncollegial at all. I mean, it has been very polite, and this is our differences of view. We sometimes have a discussion that can be quite, that has been robust, but it has never been rude. Nobody's ever told me, or I have told anybody, that I think their views are silly or stupid or whatever, or I got no respect for them, and nobody's treated me with disrespect. That has happened. So yeah, I can't remember, but there has been, it's not an easy process, I'll accept that. I'll accept personalities can clash, but I'm careful to recognize that there are clear boundaries. So, unless, Deputy Chief Justice, whether I've trespassed on any of that, I can't tell off the hand now. And I've obviously haven't got any complaints, and I've acted in so many, participated in so many appeal processes, and I've led in so many of them.
All right. No, thank you, Judge Valley. I'm going to hand over to my colleagues to put questions to you if there's any.
Thank you, Deputy Chief Justice.
Okay, I've noted you. Minister?
Thank you, DCJ, and good afternoon, Judge Valley.
Good afternoon.
Yes, my question is in relation to the matter that you handled of the Democratic Alliance versus the Minister of International Relations.
Yes.
What is your view to the fact that diplomatic and international relations matters should be left to the executive because of the nature of the polycentric laden type of matters that often arise.
Minister, I'm more than other people, I think, more than some of my colleagues, I'm sensitive to separation of powers. I really am sensitive to it. And if it might come up in one of the cases that I'll have dealt with, and I'll explain my view on separation of powers. The judgment is quite careful not to trespass on the areas that fall within the jurisdiction of the executive. However, I had to apply what I believe was a fair application of our law. And our law is slightly different than the US law on this question. In the US, there's much more deference towards an executive decision conferring diplomatic immunity. In our law, it's not. It has to comply with certain requirements, and I deal with that. I think it's something to do with the usus and an opinio juris, and I go in thorough detail with that in my judgment. So I don't believe that I trespassed the role of taking over, or trespassed the role of a judge, or entered the terrain of an executive decision-making power. As far as polycentric nature of it, I respect that, I accept that there is polycentric nature of executive decision, and that's the main reason why we should stay clear of it. But the executive has to comply with the Constitution and the law. Judges have to comply with the Constitution and the law. And in that case, I found that that did not occur. And I gave my reasons. And they've been very carefully expressed and sensitively taken, sensitively articulated. I should hope so. I never got an application for leave to appeal. If I did, I probably would have granted them, because it was a matter that does give one anxiety. Because this is a matter that involves government policy and that has implications for government actions. I'm aware of that. In fact, it's clear in most of the cases I read for that judgment, and I referred to them in that judgment.
Yeah, my last one relates to the one on Transnet and IJS Consulting, where you are dealing with a contract which you believed was loaded in corruption, and you went beyond just declaring the contract invalid. Do you think with the prevalence of corruption in our country, we have reached a stage where there should be more judgments like this, where you don't only declare it to be illegal, but you should ensure that those that participated, if you believe there was some kind of corrupt activity, should not benefit or be enriched through such contracts?
Absolutely. But and I think it's going to be a difficult issue, because sometimes you can't just supply public law principles to it. Sometimes you can, I don't know. But yes, if a contract has been marred by irregularity, and I've said this in a number of my judgments, then I believe that contract should be set aside. And I believe that whoever benefits therefrom should be deprived of those benefits. I must say this, Minister, you find some of that in the competition matters as well, collusive practices, etc. And I've not taken a lenient approach to all of them. If you look at my judgments, you see that I take quite a hard line where I see illegal and irregular practices coming out.
Thank you, DCJ.
Thank you, Minister.
Thank you, Deputy Chief Justice. Good afternoon, Judge Van.
Thank you, Acting President Petse. Good afternoon.
During your previous interview for a position in the Constitutional Court, I raised with you the number of your judgments that were overturned by the Supreme Court of Appeal. When I put to you that according to the report by the GCB, close on to 50% of your judgments that went on appeal to the SCA were overturned. Do you wish to respond to that?
I said then at the time, and I still hold on to that, I believe that it's not a fair reflection or correct reflection or accurate reflection of the number of judgments that went to the Supreme Court of Appeal that were, and that were overturned. Because there was many we don't know of where there was applications for leave to appeal. We never have that. Those that we do know, there were some that have been overturned. In fact, in my application where I'm asked to indicate how many of my judgments were overturned, I said there were 6 that I could find and 3 that were upheld. I've subsequently found that there were even more upheld, you know, that I haven't put in there. So it's very difficult to say how many were overturned. But that I have been overturned, I accept. I've been overturned a number of times. If it was 6 that I could find, then there were 6 judgments that were clearly found to be wanting by the SCA. But I don't believe it's fair to say 50% of my judgments before the SCA were overturned. I think it's less than that.
Okay, and during your interview, I think last October, you were asked by the chair of the commission to share with us the number of reported judgments that you had written. And your response to the Chief Justice and to Commissioner Malema on that aspect left me none the wiser. You were not able to tell the Commission how many of your judgments were reported or found their way into the law reports. The closest you came was that you had marked your judgments reportable. And the sense I got was that you regarded those judgments as having been reported because you had marked them reportable. Would you like to respond to that?
Acting President Petse, thanks for that question. I accept that at the time I could not tell how many were reported and where, but I could tell the list indicated which particular ones were reported, where they were reported. Yes, it said reportable and it didn't say reported. Yes, I said that I didn't compile that myself. Commissioner Malema chastised me for it. I believe he was correct to do so. I accepted it at the time, and I believe that since then I've now cleared that up. I've done this myself. You have a list before you as an annexure that tells you all the reported judgments. The Deputy Chief Justice has just asked me that question earlier, and I've told you where they are reported, which ones are reported, and I've given you a full list. I must say, there's not even a complete list, but that's to my detriment because it doesn't cover what's in the tax courts and what's in the competition appeal courts. And that's because it's just been very difficult for me with the limited resources available to actually find out where and what is going on. But I tried to do this myself. So yes, at that interview, I was not able to inform you what they were, but I certainly am able to do so now, and I've given you the full list. And it has been out there for anybody who wants to comment on my application to check it out.
Thank you. Earlier on, you told the commission that one of your greatest attributes is work ethic.
Yes.
I don't know whether you would still recall this matter of Kadak Pension Fund and others versus the executive officer of the Financial Services Board. It's a matter which had served before the SCA on the 17th of November 2017, was remitted to the High Court for further evidence and determination of certain issues set out in the order. The matter served before you pursuant to that order on 11 October 2021, counsel ready to run a hearing, and you sent them away and said that that order was ambiguous and they must seek clarity from the SCA.
I don't have a full recollection of the matter. I've got a vague recollection of it. If there's an allegation that it was sent away because I was running away from work, that's not correct. If there's a judgment call that I made that may be wrong about what the order meant, that's a different issue. On the issue of it being, on it being clarity being sought, there was a debate and a dispute between the parties as to what the order meant. Neither of them could agree on that. There were certain things that were said to me about what happened. If I recall, yes, if I recall, what had happened is the parties had written the order. It was an agreement, if I recall correctly, an agreement between the parties as to what the order should be. And the one party said that they were the parties that drafted the agreement and not the other party, and the other party said we did not agree to that. The court had just endorsed it. And so it caused a problem, and I wasn't willing to make a decision that impugns the court or that makes a decision against what that court says. I said, that court is more than capable of saying what had happened in its situation. I think that particular matter, if I remember, yes, that matter is still before me on the case management. They were not ready. They were the ones who brought this to me saying there's debating and they can't agree on it. They went back, they still came back to me. And I've had to force them to try and get the hearing held. One of them, or some of them, gave me the impression they're not wanting to go ahead and they wanted to go and seek these issues, and I gave them that opportunity. In fact, I may have set the matter down recently again without, and asked for papers to be brought in quickly. There was an intervention application I dealt with at 7 o'clock at night. So there's a lot more going on in that particular case. That case, yes, now it's coming back. That case has its origins in 2010 or something, or 2012. It's gone very far back, if I remember. It's the issue about a pension fund, an administrator having a dispute with the ex-trustees, etc. There's quite a lot involved in it, and of course I don't remember all of it because I'll have to read it, and I will read it before I meet them again. And of course, the less I say about it, the better, because the matter is still before me.
Yeah. I think we can leave it at that, Judge Valley.
Thank you, Acting President Petzer.
You would have been provided with a copy of the comments by the GCB.
And yes, I have.
And the aspect that I wish to take up with you appears in paragraph 11.1.3.
Postpone, yes, Acting
said-
President.
Are you there?
Yes, I am.
There's a reference to a matter that served before you in October 2018, which was opposed. Counsel for the applicants presented argument, and counsel for the respondent did likewise in answer, and sought to rely on a case not referred to in his heads of argument, and handed up a copy from the bar to you. And you took an adjournment to quickly go through the case. And when you came back, you didn't continue with the hearing. You in fact adjourned the matter sine die, and it had to be re-argued before another judge. Again, costs wasted. And counsel believed that you left them in the last year. You had no reason, after you had had argument, and counsel for the respondent had argued, handed up a judgment that he wanted you to have a look at. You accepted the judgment, adjourned in order to consider it, and when you came back, you adjourned the matter, effectively leaving the parties in the lurch.
That is not correct, just Acting President Petzer. And really, honestly, it is not correct. For anyone to accept that this is absolute truth would require them to actually be satisfied that all the facts are contained here. And they're not. I don't run away from writing judgments. On the contrary, I write judgments quickly, I write judgments well, and I write considered judgments, and I write scholarly judgments. That's a fact, Acting President. I would never have done this. What happened, to the best of my recollection, is the other party fell ambushed. And I thought that was not in the interest of justice for one party to be ambushed. I don't know the full details, but I also take a firm hand when someone tries to ambush somebody else. It happens all the time in our courts. So I don't believe it's fair to say that I ran away or I run away from matters. The opposite is the truth, and my record speaks for it. You have a list of judgments here that have given you absolute full details of all the cases. If anything, parties feel unhappy that I do not wish to give up the matter, that I say, let's finish the matter here and now, or as soon as we can, or can you file on a certain date, we'll then come back and hear on that. But there's no allegation, there can be no allegation that I run away from it or that I don't have a good work ethic. My work ethic is demonstrated by by the amount of judgments I've written, the quality of those judgments, Acting President Betze. And that's what one should focus upon. They're there in front of everybody to see.
Well, the judge's work ethic is equally important because it serves no purpose to be allocated work to do and you don't do the work.
Oh, absolutely. But
Because the comment here goes further and say that the matter had to be taken to another judge who had the parties and dispose of the matter
Justice Betze,
by granting the application.
sorry, Justice Betze, let's read that carefully. If it was postponed sine die, it can't just go to another judge. No other judge will just pick it up and take it. It will have to be put back on the roll, and they would have had to do and correct what was and address to any issues or problems they had before that. And that's what would have happened. So when it came before Justice Tsoka, it wasn't as if it came the same day. If that's the impression you're getting, it's not a correct impression, Acting President Betze. It's a matter that was postponed sine die. Once
Yes,
it's
this is what
postponed
the-
sine die, it means it goes back in the roll. It goes back and they will address whatever issues they have and any concerns they have. And if remember there are two parties here. There are always two parties. And one party felt that you're not taking me off guard, you're ambushing me. And you shouldn't be allowed to do that. And I haven't had the opportunity, and you can't, and this happens quite often, you can't just stand up and say after it's your turn to argue, I've got such and such a judgment, and you could read this judgment, and not even provide it to the other party beforehand, and then hand it on the side. This happens all the time, and say, here's a copy for my learned friend. That's not how justice should work, Acting President Betze. And I take a view on it. I try and make sure both parties have a fair opportunity to go through all the cases that each other wish to raise, and that they have a fair opportunity to present their own submissions with regard to that. So, and this
No,
is
I
no
accept
reflection,
that,
no
Judge
reflection
Wright.
on my work ethic, Acting President Betze. If you want to really look at my work ethic objectively and fairly, look at the judgments that are written, look at the amount of pages those judgments, look at the number of cases that are referred to in those judgments, look at the amount of self-research I've done in those judgments. There is no doubt that there's this substantial wealth of information to show that the work ethic is very high.
Thank you, Judge
Thank
Bali.
you,
We'll
Acting
leave it
President.
at that.
Lee- I'm going to interpose and put you something I should have addressed with you at the outset. I do apologize. There is a pending complaint against you
yes.
with the JCC.
Yes,
Lodged by Econ Oil, the respondent,
yes,
in a review application you had brought by ESCOM. And the complaint is that you relied on a non-existent affidavit in making your finding, and the complaint just focuses on your erroneous reliance on non-existent evidence. It's a matter that arose, I believe, according to the record, when you interviewed for the Constitutional Court vacancy earlier on this year.
yes.
You are aware of that complaint,
I've responded to it.
or you have? Because
No, it's all done. The complaint was lodged 9 months ago. It was brought to my attention about a month ago or 2 months ago.
the one I'm talking about was lodged on the 28th of August, just last, a few weeks ago.
I thought it was 28 August 2021. I'm not
Sorry?
sure. But it was lodged because it refers to my candidature as in the Constitutional Court. But I don't want to skirt the issue. I think I want to address the issue. I think one person sitting here was probably counsel in that matter. You know, but yes, I did, and it was pointed out to me that I referred to an affidavit. I said that there was a confirmatory affidavit, when in fact there was not. And now I've looked into the situation, I've come to the conclusion, yes, there was no confirmatory affidavit. But I must say this, and I said this then, that if there was an error, it is blown out of proportion. It is not a significant error. It did not affect the outcome of the judgment. It would not, and I can refer to it now. In fact, if people want to go and look at the judgments, they are before this. I have submitted that judgment as one of the judgments for people to consider. And I think, I don't know where it is in this document.
DCG.
What are you looking for?
The
DCG.
actual
Let me see.
reference,
Yeah, finished.
Okay.
sorry,
Sorry about that, just carry on. Did you find what you were looking for?
It's on
I would-
page 311, Judge Valley.
thank you, Commissioner. 311.
And while you are looking for page 311, I mean, just mention that the concern actually is that you would just cursorily dismiss that kind of error as a minor issue. It's your approach to your committing an error of that nature.
You know, let me start by saying a few points. First point, this was a matter involving, it was a special motion, and the papers before me were over 4,000 pages. This is one matter that taught me, be careful of working till late at night all alone with all these papers. But let's look at the error, and let's look at this point you raise, Deputy Chief Justice. The error is to be found on page 5D or 5E, paragraph 5D, let's notice. Right. Right, on 5D, in that page 315, I record that the very person had issued or had made a report. I put down what his memorandum states. And he says what happened with regard to this issue. Then I say in 5E, and this is where the error lies. It says, Mr. Shitangano and Mr. Hevu have both provided sworn testimony in the form of confirmatory affidavits. That's the only error they've identified. It should have had only Mr. Shitangano has provided sworn testimony. Mr. Hewu did not. That's what they're saying is the error. Looking at the judgment as a whole, it's an insignificant error insofar as the outcome is concerned. That's been confirmed by the Supreme Court of Appeal. It has been refused leave to appeal. They've then petitioned that to yourself, Deputy Chief Justice, and they've brought that to your attention. You have refused them the petition. So, Deputy Chief Justice, that error had no impact on the outcome. There is a lot of other testimony that goes on. Mr. Khalib Kesem gave a supporting affidavit. I simply mistook the view that Mr. Hewu had provided a confirmatory. In the amount of paper around me, I thought I saw it. When I wrote this particular paragraph where this said so, I thought I had done it. It was wrong. I admitted it's wrong. It's a regrettable error, but it has not affected the outcome of the judgment, and the judgment has been upheld. It has been upheld by the Supreme Court of Appeals.
Yes, indeed. What you said in the latter part of your statement is actually what I think these parties themselves, including me, were looking for, that expression of regret for committing the error. Because
No, it was a regretful error, and I really regret it. I mean, I've made many errors of fact in many judgments I've written. That's why you get overturned. And this is one of those, but fortunately or unfortunately, it did not affect the outcome of the judgment. In fact, the judgment, as I say, is quite lengthy. It goes on right up to page
Well, the
350.
SA did dismiss the application for leave to appeal, and that was the end of it.
Yes, it was,
It is
well, they
just your-
petitioned.
Yeah.
What I must say, in fairness to the person who brought the complaint, in fairness to that person, is this. The person felt that when I said to this body that this issue is being blown out of proportion, now remember, this thing was a newspaper article that supposedly came a few days before my interview. And so it was just brought to my attention at the interview, and some members of the commission complained that I was being ambushed. And they tried to cut it short, and they said it's not fair upon me. And I said, that error was never pointed out to me. It was never pointed out to me at the application for leave to appeal. So what I said is, had it been brought before me at the application for leave to appeal, perhaps I should have. And perhaps, and now that they've petitioned, perhaps the SCA will take a different view, because it's been brought to their attention that there is an error in this judgment, which error is simply that did Mr. Hewu confirm. Mr. Shitangano does it, Mr. Kalib Kesem does it, but did Mr. Hewu also do it? It's just a third confirmatory affidavit. And I said he did, and that was wrong, and it's regrettable. And they said, well, if I said that, then why did I not grant leave to appeal? But it wasn't brought to me when I brought the application for leave to appeal. It was not brought to my attention at that point. And I dealt with this judgment till late hours in the evening. Counsel is sitting here. They tried there was all attempts to try and get this matter moved on. First attempt was to say, let's call 3 bench or something. There was some other attempts afterwards, and I said, no, you file your heads, leave them limited time, and I went through and I gave the judgment. I think I finished it in 2 weeks' time or weeks and a half's time. 29 June. Took me about 20 days. And it was very, very, very large matter, voluminous matter. But I regret the error. I honestly say to you, I sit here remorseful about that error. Small as it may be, it is an error.
Thank you,
Thank
Judge
you,
Vali.
DCG.
Thank you, Deputy Chief Justice. I'm sure you would I want us to correct this for the record. When Judge Valley was responding to what the acting president was saying, he said, don't bombard me, was something that was never brought to my attention. But according to the records in front of us, it is something that was raised by the GCB, and all the candidates received the objections that are coming to them. So this thing of synergy,
I'm confused.
this thing of synergy, it's here in the objections coming from GCB. And that was what was raised by acting President Betsy. I just want to put it correct for the record, because he said we are bombarding him, and the JSC have got this negative name outside of bombarding people. So I'm putting it for the record that that is not something that is coming out of the blue. It is part of the records that was there, and that is what I want to correct, please.
Thank you for bringing that to our attention, Commissioner. It's noted. Do you want to say something, Judge Vali?
I'm not sure. I'm not sure I understand what's going on.
DCJ,
I have to ask.
if I may just come in before the candidate does. I think with respect what Commissioner Lucas is referring to is when Judge Valley was reciting what was happening before him in a matter, not that he was accusing you of bombarding him with new issues,
I'm quite confused.
unless I'm mistaken. I must say I share Commissioner Singh's understanding that Judge Valley had said in the previous round, the newspaper article had just come out, and it was at that point that someone had raised that he was ambushed. He's had no complaint in this hearing.
That was my understanding of what he said.
because as Commissioner Lucas says, everything that's been raised so far has been in the GCB's report. So I think is that a fair?
I think it's fair. I think I have said, and I've tried to be as fair as possible to the person who complained. I've responded to it, and I've said, I've accepted that there was this error. What happened last time, what the complainant does is afterwards, I said, but this is how you answered in the JSC, and it indicates that you should have granted us leave to appeal because you now show that you accepted you were erroneous. And I'm saying no. The difference is that issue was not brought to my attention at the application for leave to appeal stage. And that's why I did not say anything to this body at that interview that contradicts what I'm saying now.
All right.
Because that's what the difference is. As far as the ambush issues, I'm never saying that acting President Petsa is ambushing me. No. No, he's never done that. Nobody's done
Understand.
that. This is something different. I think our lines are crossed.
All right.
Thank you.
Thank you, Judge Valley. And may I just ask that going forward, you try to keep your answers concise, because when you say a whole lot of things, then, the brain tends to switch off and we miss some of the things.
I will
and
do
it just
so.
becomes
Thank you,
confusing.
thank you, thank you.
Let us try
Thank
to
you
be
for the
crisper.
advice. Thank you.
Thank you. Judge Pillay, your hand had been up at some stage. Do you still want to put questions to him?
I do, thank you,
All right.
DCJ. Judge Valley, good afternoon.
Good afternoon,
I just wanted
Commissioner
to
Pillay.
I just wanted to refer to the letter received from certain silks at Tulamela Chambers. I
Yes.
think it's by Maleka SC, Maroka SC, Bukaba SC, Mukwena SC, Nalani SC, and Brian Lichoche SC.
I think you left out Kabashi SC.
I'm not seeing her name on the letter.
Is it
maybe.
not? Okay.
I think she's probably left the Bastons.
Oh, I see.
I'm talking about the latest letter.
I'm sorry, yeah.
No, you're absolutely correct. The latest letter also has Babashe SC as well.
Yes.
Where they raise their support for your candidature, and they want this commission to take into account their view that any criticism about your temperament, that is not a view widely shared by members of the Joburg Society of Advocates. I don't know if you see that in their letter.
I'm going to look for their letter. Can anybody?
It's not paginated.
I'll find it.
It's under a folder called Letter of Support.
Letters of support. Yes, I found my version of it.
Yes.
I brought my own copy, yes. The one dated 26 August 2022?
That's correct. So, and what that letter does is it endorses an earlier letter, again sent by the same set of silks, dated the 9th of September 2021,
Yes.
in which they go at length into describing your work ethic. And you'll see
Yes.
that in paragraph 14 of that letter. Now,
Yes, that's the earlier letter you referred
yes,
to.
so the later letter incorporates the earlier letter.
Yes.
And perhaps you just want to take us through what it is that these silks are describing. They go at length and they identify specific incidents or kind of work patterns that you've adopted in order to meet your obligations
Yes.
in the Joburg High Court.
Commissioner Pillay, I find myself really inundated with a lot of work. And they were some of those people who had to appear before me in some of those matters. And I find that it is really difficult to just work within working hours and finish my work. And I tell that to counsel and I try and get it done. They witnessed it. They've also witnessed me in a number of other matters. And it was very kind of them to come and bring it to the attention of this committee to say that their experience has been very different from the experience of other people or the unnamed persons in the GCB one. And they said they want to go on record saying that I've had this high work ethic. And I can't take it further than saying that I'm actually humbled by what they say, that I have considerable diligence, self-sacrifice, and devotion to my role. They say he avails himself, he hears matters late into the night, he avails hearings into hearings in the evenings. I mean, when I sit in an urgent court, I go through, if I have to go through till late, I do so, you know. But even in these special motions, they're very difficult to deal with because the paper is voluminous. And they've seen it. And they've also had discussions, I suppose, with each other, I don't know. But I'm humbled by what they say about it. And I would certainly think that's a fair reflection of my work.
Judge Valley, the second issue I wanted to ask you about is the fact that you sit now as the senior judge on the Competition Appeal Court.
Yes.
Now, when you were a member of the bar, did you do any competition work?
None. And some of this is going to come out in the next interviews, so I don't want to say too much. But what had come out to me when I got there, and I got there after 6 years on the bench, that this was water over duck's back for me. It was just anybody can do this work. I have been asking other counsel to get involved in this work, and I'm going to raise this when we come back here another time. It's not work that's given to a lot of counsel, most counsel, in fact. And yet it's work most counsel can do. And there's a handful of counsel that only had that work, but from my sitting on learning the matters and deciding the matters and writing judgments that have received the praise, I found that this is really an area that is unnecessarily presented as something special and outside of the reach of all counsel. That's not true. I think many counsel, yourself included, and you've appeared before me, and I've had your heads of arguments in some matters, would easily walk into this area. I think many counsel. So I didn't appear in that court, but it did not handicap me from sitting in that court. And now I'm what's effectively the acting judge president of that court.
Thank you. Thank you, DCJ.
Commissioner Pillay, the judgments I've written in that court have been upheld by the Constitutional Court. They were dissenting judgments, or at least I know one of them.
Go ahead, Prof.
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
Now,
Commissioner, I can't see your name.
Oh, Marumo Achai.
Marumo.
Yes.
Thank you. I know Marumo. I've never heard Marumo Achai.
Now you
it's
have.
the first time. Thank you, Commissioner.
There is, picking up on what Commissioner Pillay was talking about, it is not the matter that I wanted to ask you about, but it really triggered my mind because I remember reading one of your judgments in competition law, just don't have it in front of me now. Isipani. Yes, you remember that matter?
Yes, Isipani.
Yes. Where you had to deal with...
Is it not in my list of judgments?
It might have been. It might have been. I read it quite a long time ago. I think that judgment dealt with Section 4.1 of the Competition Act. And in particular, collusive bidding and rigging and all those things, cartels basically.
Yes.
And I say this because something that happened in my classroom, right, in my lecture hall. I think you said something in the first few paragraphs of that judgment. You referred to unlawful collusion, the word unlawful collusion.
Yes.
And the debate in the class was, but can we really say that a collusion is unlawful? Because collusion generally is per se illegal. It's one of those restrictive horizontal practices that the rule of reason won't apply to it.
No, I see your point.
Yes.
I get your point.
But that's not the matter I wanted to ask you about.
Yes.
The matter I wanted to ask you about is in relation to the National Union of Metal Workers of SA versus VR Laser Services.
Yes.
You remember? And this case is important, and I think
business rescue case.
the business rescue one, and I quite enjoyed reading this judgment, and I think it is one of those important contributions where the judgment per se deals with business rescue, but it intersects to some respects into the aspects of labor law, right?
Yes.
Where you have to deal with Section 189 of the Labor Relations Act.
Yes.
And I see that you, in the judgment, you focused more on the security that creditors have during business rescue and the role of the business rescue practitioner in relation to disposing of those assets during the process of business rescue. And I agree with your reasoning. But the thing is, you also referred to Section 189, and you did not go to the distance with it. But I just want to ask you a general question in relation to that. There is an issue currently in the labor code where the issue of forum shopping is actually arising in relation to retrenchments that employees bring during business rescue proceedings. Because the argument is business rescue provides you with a moratorium, right?
Yes.
Then that means one cannot be able to be taken to court, litigated against, and all those things. You are given 3 months to breathe, so that those things happen.
Yes.
Just want to understand, how do you see the South African law developing in terms of retrenchments that are brought during business rescue proceedings?
Well, I mean, we already have a lot of checks and balances in the law itself. They need to be part of it, they consulted, and they are made, if I recall, preferent creditors. There's something about post-finance debt and pre-finance debts and something to that effect. Just for the record, VR Laser was a very painful case for me. And the counsel that appeared before me was involved with me in my struggle days. And I said to him, the heart bleeds on this case. Because what had happened there is that those employees were asked to work for 3 months without pay. And now when it came to having to pay them their back pay, it was told this money is going to go to the bank. And then I looked at the law, and that's when it came out that unfortunately it had to go to the bank and not to them. And it was quite painful. There's some really heart-wrenching affidavits put by some of those employees as to what was happening to them in their lives. But yes, the 189 process does provide for that, and fortunately, some of the unions do take advantage of that. It's a long time since I worked in labor law. I was very good at it when I was at the bar, and it's because I was a trade unionist. So I know labor law fairly well. I know it from the side of the trade union, so yeah. And I know what happens in the retrenchment processes. But I was one of those who argued at the time that the consultation process must be a meaningful process. It mustn't just be a formalistic process. I consulted you, I can dismiss you now. It's done. In fact, if I recall, and it's going back more than 20 years ago, Justice Malambo wrote one of the leading judgments at the time on what consultation should mean. And I was one of those who was a strong proponent of that view. So what we can do here is give them, maybe we can, and the court can probably ensure that their interests are receiving the due attention when the business rescue practitioner is already running the process rather than only just their creditors.
No, thank you very much, Judge Valley. I think on a lighter note, I realize that your judgments in most of the cases are pretty long.
Yeah.
I think you need to practice reducing them, which you will be successful to the Supreme Court of Appeal, because this might work in the Constitutional Court, but I doubt in the Supreme Court of Appeal with the guidelines that are available there, this might work. Perhaps a judgment like this, it might take 17 pages or so.
I'm happy to learn. In this profession, we learn every day. I'm happy to learn how to. But I also hope, Commissioner, that they also have academic value. You said to me it was in your class. So I also hope they have they also have scholarly value.
I wouldn't comment on the scholarly, but yes, definitely value, certainly.
Well, okay, thank you. Thank you.
Any further questions, colleagues? Oh, sorry, Commissioner Steinberg.
Afternoon, Judge Valley.
Afternoon.
I'm the member from the GCB at today's hearing. And it's
Well-
incumbent upon me to raise some of the concerns that they have raised
Yes.
in the written report before you.
Yes.
Firstly, to say, I read the letter from my colleagues at Tulamela, and I think there's a lot of truth in it, and they certainly hold that view dearly. But I don't think that erases those who hold a different view. And there are many in Tulamela who asked me to please raise that concern about temperament and rudeness. So I merely ask you to acknowledge that the positive view doesn't erase the negative view, and perhaps it's something that you could take on board.
I'm happy to take on board, and I'm happy to change my ways where I'm wrong, and I'm happy to admit where I'm wrong. I am wrong I can be wrong many times. But it also helps Commissioner Steinberg. If one gets details and one gets told this is you were wrong here, so then you can actually absorb, digest it, you know. And once you absorb it, then you can make changes. It's sometimes very difficult to do so. It comes across as if you don't take that criticism into account, but you don't if no one brings it to you. I would like them to raise it up front and say this is where it was and this is what went wrong. I would certainly take note of it. I'm very happy to change my ways in any of that.
Thank you, Judge Valley.
Thank you.
One of the issues that hasn't been raised, on page 140,
140.
paragraph 14.2, I can actually read it to you, it's not long. The GCB says, the candidates sometimes disregard for binding nature of precedent.
Okay, I know that one.
And in
Yes.
particular, his reliance on his own decisions is concerning. Even if the candidate has sound reason for disagreement with the higher court's decision and articulates this in the judgment, precedent is binding. Failure to follow precedent may be interpreted by the public as a disregard for the rule of law. And then they give, I think, 3 examples
Yes.
where the appeal court has expressly criticized your judgment
Yeah, let's look at these
For-
examples.
disregarding clear precedent. One of them is the Capitec Coral
Yes.
Lagoon judgment,
Yes.
which I see in the transcript you were questioned about last time.
Yes.
And you responded by saying that the problem had something to do with a conflict between the approaches of the SCA and the Constitutional Court. But the question wasn't followed up, and I'm interested to do so now. What did you mean by that?
I don't know what you're referring to as what was said last time, but let's just take this issue one step at a time. The first issue is, as I understand it, is disrespect for or non-compliance with precedent. I think that's the first and most important issue. I think that's not correct. And I think as a statement, it's very important to accept what they're saying is true. The stare decisis principle must be applied, otherwise rule of law becomes meaningless. There's no quarrel with that point. Did I not follow? That's the underlying theme. Did I not follow? And I see you nodding, meaning that's the question. That's what the focus is on. Did I not follow precedent? My answer is no, that's not correct. At the time Capitec was out, Biedeka was not out. At the time I dealt with Capitec, I had written Atlantis, a very detailed and carefully thought out judgment, which judgment, by the way, has been supported by Froneman J. in Biedeka. Of course, he's a minority, but it was. If you look at his judgment, he talks about the same issues. But what I did in those cases is followed Botha versus Rich, which is also constitutional court authority.
Sorry, you followed what?
Botha versus Rich, which is constitutional court authority, which I drew from and looked at in the context of its previous constitutional court judgments. Barkhuizen was one of them, Everfresh was another one of them. And I said, this is the precedent that is coming out of the Constitutional Court. And applying that precedent, this is the conclusions I come. But at that stage, there was this debate as to what exactly is the one that's coming out of the Constitutional Court what's law, or is there a difference between what they're saying and what the SCA is saying? So I followed, as far as I can understand, the Constitutional Court. Since then, the Constitutional Court has clarified its position.
But in those cases you mentioned, pre-Badika, the Constitutional Court in no way said that the express terms of a contract can be disregarded if it's unfair, in the view of the judge.
No, I don't know if we're on the same wavelength. I've never said that express terms can be disregarded just for that reason. I've said express terms must be interpreted in a specific form. And I said, if you look at, and you need to look at Atlantis very carefully. You need to look at it because you can't read Capitec without reading Atlantis.
Judge, I can assure you I've read
And
those
so,
cases.
in Atlantis, I spell out what the Constitutional Court says as to what the approach should be. I then look at what the Constitutional Court did in Barkhazen, what it did in Everfresh. I also say that what the Constitutional Court said in those cases appeared to be different from what the SCA said in Bredenkamp. And in Bredenkamp, they had their own in Biedeka, Froneman tells us quite clearly, Biedeka, as far as he's concerned, Bredenkamp, as far as he was concerned, is wrong. So I was grappling with those issues, but to say that I've just gone ahead, I don't know about unfairness. I spoke about good faith. And good faith is an important consideration. In fact, it's one that's bedeviling the contract law all over the world. And one of the better judgments is that in the Canadian courts. There's also Lord Steyn, who's a previous South African, who's also written a number of extrajudicial articles on good faith. So I've looked at good faith and I've looked at our courts' judgments on good faith. And I went right down to the beginning of it. So I don't think it's correct to say I ignored stare decisions, I ignored precedents.
But you did expressly follow your own minority judgment.
But it was following, but that judgment is followed, and I said in that minority judgment that I'm following Constitutional Court judgments. I'm following what the Constitutional Court has said. And that's where the difference lies. It's a debate I'd love to have with you. And I'd love to have them with the judgments in front of us, all of those judgments.
Okay, I'll leave
And then you'd be able to see. I was just told I should be careful about being over-elaborate in my answers.
No, I accept that.
And I'd love to have this debate. In fact, after writing Atlantis, I was quite happy to give a lecture. In fact, I was invited by one group to come and lecture to their group members, and then they invited everyone else. And then I don't know what happened. I can't remember the entire details, and it didn't take place. So I was quite happy to face anybody and say, and discuss with academics, advocates, whoever, and say, let's look at it. This is an issue, of course, it's going to be a difficult issue. It's going to be with us for a long time.
Judge Valley, the fact remains that...
Has the point not been made, though,
I would just like to conclude this point.
Okay, all right.
With your permission.
Yeah. Let's just try to round off.
That the GCB points out 3 judgments of the SCA, which 2 of them expressly upbraid you for not following precedent. Those are the Capitec case and the municipal workers case. And in the De Beers case, they note that the judge was shocked by the sentence you imposed, suggesting again you haven't followed precedent.
Oh, that's a different matter now.
No, no.
Sorry,
let
De
me
Beers
ask-
is a
no, no,
different issue.
Let me ask my question, Judge.
Yes,
There are 3 judgments that are
Right.
pointed to here.
okay, give me the paragraph number.
Paragraph 7.3.5.4. So we're on page 130. 131, I think.
7.3.5.4. Right. Right. 7.3.5.
No, no, no. Um, 7.3. We're in the 7.3s. So 7.3.4.2.
That's the one about the LRA.
Yeah,
Ms.
that's South
Steinberg.
African Municipal Workers Union.
Okay, Ms. Steinberg, we heard earlier about forum shopping. This is a matter in which the union came to the High Court. And the question was whether the High Court has jurisdiction or the Labour Court has jurisdiction. I applied what I believed, or what was my understanding, of a constitutional court judgment called Kaba. Kaba is a judgment that talks about when you can go to the Labour Court and when you can go to the High Court. The SCA said no, they should never have come to the High Court, they should have gone to the Labour Court. I respect there were different, we came to a different conclusion. But there was a constitutional court decision, and still, anybody who knows labour law will know Kaba was a leading case. In the early days, when we had this huge uncertainty as to when can you go to the Labour Court and when can you go to the High Court. And there's a number of judgments before that as to, well, I think they have concurrent jurisdiction, they have this. So this particular case is, there was a special plea, and it was a very long time ago, it was 2016. There was a special plea which said, you're in the wrong court. And I said, no, but they're not in the wrong court because they're not raising labor issues. They're not relying on labor law rights. And Kaba says they can't come to this court when they're not. And that's the conclusion I came to. I've subsequently been overturned by someone. But you must, if you want to understand these issues, Commissioner Steinberg, you need to know a lot more about what the law stands for.
No, I take issue with that. You're suggesting I don't know what
No,
it
no,
means.
I'm saying, no, I'm not suggesting. Please, I apologize if that's the suggestion I made. No.
My final question. Are you saying then that in both cases where the SCA expressly upbraided you for not following clear precedent, they are wrong?
No, what I'm saying is, they may be right by saying, I misread Kaba. But I applied Kaba. No. Are we understanding each other, Ms. Steinberg?
We are. Thank
Please,
you,
if
Judge.
there's any issues you've got, I'm happy to clarify them.
Thank you, Judge.
Right on. Thank you. Commissioner Lucas?
In the interest of time, let me forgo my opportunity. In the interest of time, yes, please.
Okay, thank you. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good afternoon, Judge Bali.
Good afternoon. I can't see your name because you're not appearing on the screen.
Muimang,
Wimang.
yeah.
Thank you, Commissioner Wimang.
Just 2 areas that I want to converse with Judge Valley. The first one is the question that you responded to in terms of what is to be done with contracts that are made by corruption
Yes.
in the Transnet versus IGS Consulting. If we could just explain the importance of ensuring that the beneficiary of corruption do not benefit from the fruits of corruption. If you can just elaborate on that. But it's also linked to the point that was canvassed earlier on ECON versus ESCOM, because both are matters of state owned entities that were recently in the news, not only as a result of corruption, but also the issue of load shedding. And I think the thrust of the judgment respond positively to the calls to stem out corruption. Now, the second point is taking further the point that was raised by the minister in the matter between DA and the Minister of International Relations. And I appreciate the acknowledgement from your side that in certain instances this matter are polycentric. However, given the judgment, which is more or less similar to what happened with the al-Bashir matter, because in that instance, the executive took a political decision because of our approach to international relations, which is correctly captured in Chapter 7 of the National Development Plan. Our entry to the global politics is through Africa, and more so the relationship that our country has with the former frontline states and the SADC region in particular. Don't you think that sometimes in matters of this nature, the courts should exercise judicial restraint? And linked to that, don't you think that sometimes judgment of this nature are the one that leads to the criticism of our courts, and also Clarion calls for judicial deference in certain matters of this nature, and also calls for a change in terms of our democracy, moving away from constitutional democracy to parliamentary supremacy, under which judicial action is extremely limited and not much is expected on the proactive role of the judicial action. Thank you, Acting President. Thank you, Judge Valley.
Thank you. Acting President.
Thank you, Commissioner Moima.
Acting President, I'm going to try and give a short answer. I just want to say I respect that there are polycentric issues. I also respect, and more importantly, this is one not focused on, I respect that the executive make decisions in ways and on basis very different from the way courts do. What we regard as law of evidence, they don't necessarily regard it. If they find something is a fact, they don't have to have it proven, and they make a decision on that. That said, so therefore I accept, and a third point I accept, is that courts must never assume that they have greater wisdom than other branches of government. But at the same time, I say that those branches of government must operate within the rule, or within the Constitution and the law. I say courts too must do that. And I've done, and I say that's how we'll only solve this problem. I'm not sure, as far as issues of parliamentary supremacy and that is concerned, I don't want to get into that in this forum. I know it was not accepted by our government in 1993-94 when we had this changeover. We specifically went for constitutional democracy. What happens from now on, I don't know, it's not in my purview. That I leave for people better qualified than myself. Thank you.
Judge Valley, we are almost at the tail end of your interview. And before I excuse you, is there anything that you want to say to the commission? And if so, I will allow you only 3 minutes.
Thank you, Chair.
Sorry, AP? Sorry, AP, have you remembered?
I'm sorry. I'm sorry, just bear with me for a moment, Judge Valley. Commissioners who are on the virtual platform, Commissioner Barnard?
Thank you, AP. Judge Valley, I'd like just want to take further the question about the criticism of the GCB regarding certain of the judgments. And the question I have is with regards to the judgments that have been overturned on appeal, what lessons have you learned? And I ask it specifically against the backdrop. I've categorized the criticisms of the higher courts of your work into 3 categories. One is regarding evidence. So in the Morocco versus Chemical Industries, which is referred to in 7.3.1.5, they criticize you for not interrogating evidence properly. And then in 7.3.54, in the Lecca property versus right, the criticism launched by the court is your manner of conducting the trial by allowing a witness to read the evidence extensively from the affidavit. So those 2 I've categorized under evidence. The binding precedent, my colleague has already questioned you on. So that's the Capitec and the SA Municipal Workers Union, which were both dealt with it. In the SA Municipal Workers Union versus Mokgatla, it was said that you failed to follow two principles laid down by 2 constitutional court matters, or the principles of that. And then, of course, there's the errors in discretion with sentencing, which induced a sense of shock on appeal. So those are various things. So with all of that backdrop in mind, what are the lessons that you've learned from matters where matters have been taken on appeal?
No, I think it's very important to learn from other people as to where you went wrong. It's a hard job to sit alone first time round and make the decisions. And I accept that I've been overturned in these judgments. And I think the lesson to be learned is try and be more careful and take note of what they've said as to where you went wrong. So the next time you get the same case, I'll now know where to go. I'll look at what they've said with regard to that. So yes, I will take on board whatever criticisms they've made. If you want me to respond to each one of them, that's a different matter. I'm not sure I understand you to want me to do that.
No, it's just a question generally.
Generally, yes. No, then I've answered. Then I believe what it has taught me is just take note of what they've said if ever you get the same or similar case again. I will take that into account.
Sorry, I interrupt you.
Sorry?
No, okay, I thought I interrupted you.
Oh, is it? Sorry, are you on? No, I was saying, as far as I will definitely take note of what they've said in those cases. But, I mean, as you say, you don't want me to respond to each specific one. So my answer is a simple one, which is they've pointed out to me very significant errors on my part, and I must take note of them, and I will take note of them. And then do so when I continue in my next case, other cases. I've done that. I will do that. I do not believe I have all the answers to all the problems.
Thank you. My last question is just, what would you say to if someone were to argue and say that, when there are matters being investigated by the JCC, it might be wise for these JCC to first, hold
the fort.
Wait the outcome of that before making a recommendation.
I would caution against following that approach in this case, because I believe that unfortunately that was brought to me so late, but I've explained why I think there's no merit in it. And I believe that the Supreme Court of Appeal has already pronounced on it. The Supreme Court of Appeal has found the judgment to be unimpeachable. And if that is so, then the judgment's correct. What's the complaint can have no merit in that circumstances. The complaint, and I've tried to explain here and now for the public and everybody to know what the complaint's about. And I've admitted where the error was, but it doesn't affect, it does not affect, it does not affect my answer, which is that there's no merit in it. And there's no reason to wait for that. There's no reason to wait for it. It's unfortunate it came to me so late. It came to me just a month ago. And there's a danger if you follow that, Commissioner, that somebody can just do that in the last minute. Something that happened last year. And if they can do that, then they can frustrate you. So you also have to take that into account, Commissioner. I can't see your name, Commissioner, so please accept my apology if I don't call you by your name.
Thank you very much. It's Commissioner Barnard, and you have answered. Thank you very much.
Thank you,
That's
Commissioner
my
Barnard.
question.
Thank you, Commissioner Barnard.
Just a small point of correction, Judge Valley. As I understand it, what went to the SCA was actually just an application for leave to appeal, which was
Correct.
dismissed.
Correct. but
And you
it-
said the SCA has found your judgment unimpeachable.
Which means that no other court will come to a different
I'm
conclusion.
just reacting to the unimpeachable. The SCA has not delivered any judgment on
no.
the issue.
I'll accept that.
Yeah, it
But
may
when I
just have
meant-
agreed with the result
Yes,
you gave in your judgment. That's
yes.
it. Just that tiny correction.
I'll accept that.
Yes.
A follow-up on DCJ, follow-up? Yes. Judge, I just want to, in most instances in a country where you have different courts, lower courts and superior courts, there seems to be this idea that when a lower court is overturned by a superior court, as a matter of fact, the superior court is correct. And I think we will be doing ourselves a serious disservice if we adopt that kind of analogy. Yes, of course, lower courts can be wrong, but so too the superior courts. Now the question is, when you get a judgment of a superior court that overturns you, do you engage with it just to see perhaps maybe your reasoning maybe was flawed? How do you kind of like deal with it?
It's a complicated issue and it's a complicated question. First thing I must point out to you, sometimes the case they take to the superior court is not identical to the one they bring to you. They can change emphasis, they can change, it becomes more nuanced. So then you don't know whether you've learned any lesson when you read there because it was not put before you. So that's that. But where it was put before you and you came to a different conclusion, then you must accept. If you were wrong, you must accept it. And I'm accepting that. I don't think one must ever take the view that they're always wrong and you're always right. That's wrong. And anybody who holds that view, I think, needs to reconsider. So yes, and then the other view, sometimes the superior courts, sometimes you find the first judge has been upheld when it goes further. Good examples are a first judge gets overturned by the SCA, then gets upheld by the CC, Competition Court. That's happened so many times. So, but if you catch the person at the moment where we only have the SCA judgment, you'd say, but you made these errors. And then comes, of course, the Constitutional Court and they say, but we don't think there were those errors. So it's very hard. It's a very difficult situation. And of course, it will have to be dealt with on a case-specific basis. And you have to look at the criticisms carefully. You need to look at it. So yeah, I'm with you. I agree fully with you, Commissioner.
Thank you very much.
Commissioner Marumo
Achai.
Achai.
Commissioner Breitenbach, do you have questions for Judge Valley?
Thank you, Deputy Chief Justice. I'm covered.
Oh, thank you. Judge Valley, I understand that my colleague on my right had given you an opportunity to address us.
Thank you very much.
Just briefly, if you have anything
Thank
at
you.
all
No,
to
I
say.
don't have anything I wish to say. I just to say thank you for the opportunity to present my candidature to you.
Thank you
And
to you
thank
too.
you, Will.
All
Thank you.
right, your
Thank you.
excuse.
Thank you all.
Mr. Chair, it looks as though we are going way beyond the 15 minutes that you tried to keep us to, or within. I think we need to strive. This board is capable of limiting its members to 2 questions, but only in extreme situations that we can go beyond 2 questions. And even those 2 questions must not be too, with preambles and all that. Thanks.
You're quite right. Well, it has not helped that some of the candidates tend to be long-winded, and I'm loath to interrupting a candidate in flight. Being interviewed is a tough experience as it is. But I think the responsibility lies with us just to be careful with the way we couch our questions. Half of what is put to candidates is actually not questions, but debates, and then ends up being a long dialogue.
And also that, DCJ, if you think your question has been answered, you can, inform the candidate that, no, I'm actually covered, so that he or she doesn't go beyond what you already were looking for.
But, Deputy Chief Justice, I thought it's lunchtime or something. I thought it's lunchtime. Because we are left with 2, and if we come back and take the approach that he is indicating, we'll still be in order.
DCJ.
I'm sorry. I was asking if we could not just interview the next one, because it should not be long with someone who's been here before, and then we can break off for lunch, especially after the warnings that have just been issued by Commissioner Club. I think we'll be more exerting with how we ask our questions.
I thought the minister wants to come in here.
Oh,
The reality is that we're very hungry.
you are hungry?
Yeah.
All right.
And it looks
argue
like
with that.
it's still 2, so I think.
Can't argue with that. Okay. How long is this lunch going to be? A full hour? 30 minutes?
No,
Yes,
I
yesterday.
also want to speak about that issue of 30 minutes, because remember that we work here and we work somewhere else. So during break, we try to respond to all of the things that are happening in this country and eat at the same time. So we take the 30 minutes to eat and take the 30 minutes to do some work. So and that's how we accepted to come and spend all of these days here. So when you restrict us to 30 minutes, we completely lose the whole week. And it's not going to work for some of us, because we all sitting here know some of other responsibilities that we hold in society. So it can't be that we are non-available for the whole week. So 30 minutes is for eating, and 30 minutes is for doing some work, and then come back and concentrate here, because it's not decent that when a candidate is here, you see an important call, you rush outside. This committee looks like it's not organized. So we allow calls to pass because we'll attend to them during break. So 30 minutes, it disadvantages some of us.
Colleagues, what do you say to this?
Because when we adopted this thing, you said we have a break for 1 hour.
So we take an hour then?
Yeah, but when we come back, we strictly
It's too
stick
sharp, so
to what Honorable Kaba was saying.
3, we should not be making our way back here. We should be sitting here ready to start with the candidate. Is that a deal? All right. We'll come back at 3, at 5 to 3.